Gross on behalf of the people.
Assistant Public Defender Chelsea Gill, with on behalf of Santana Taylor. Mr. Taylor, please state your name.
Santana Taylor. Thank you. What are we doing?
Your Honor, I would ask for an adjournment on all three cases. On the two newer ones, we're still waiting on some discovery, and just to keep them all together, if we could get a 2 to 3 week adjournment on all three, and if you would allow, may I address bond?
Go for it.
Thank you, Your Honor. So I understand currently he's got a bond on all three cases, and I would ask you to consider releasing him on a home confinement tether. My client stresses to me that the most important aspects of his life truly are in jeopardy if he is to remain in custody until his next court date. His mother is very ill. She has dialysis. He helps take care of her. Additionally, his dog is at home, and he's very worried about the life and well-being of his dog. He applied recently to Washtenaw Community College, and for HVAC classes, he would very much like to enroll in those and progress further in his life. I understand he did miss the last court date on February 27th. He expresses to me that he had strep throat at the time, and he went to urgent care for that. I unfortunately don't have documentation regarding that, but he did intend to come to court, although he was sick at that time. So being all these things, these are things that keep him here and that are really important to him. I would ask you to consider releasing him on a tether.
Sorry. Go ahead.
So this is a case, well, the first case is one where we requested a $100,000 bond because of the home invasion. Second, that is DV related. The defendant failed to appear for that case on December 21st, and a bench warrant was issued with $10,000 cash surety. Then the defendant failed to appear on January 18th, and another bench warrant was issued for $10,000 cash or surety. He appeared on February 8th and requested an exam for which it was set on February 27th. My understanding is that didn't happen because he had strep throat. While he was out on February 21st, he picked up a strangulation that is against a different DV victim. During that strangulation, he went to the victim's apartment while she was sleeping. She had put belongings of his outside her door for him to pick up. She woke up and because of him, and he began to argue with her. She then told him to leave. He pushed her, and she admitted she pushed him back. He then kicked her in the shin and choked her before pushing her to the ground. She said that she was lightheaded and struggled to breathe while he strangled her. In that case, we requested $100,000 and were only given $5,000, 10%. That offense date is February 21st of 2024. He was not apprehended on following that incident for which he was not apprehended. The defendant then picked up another charge of R&O. The offense date on that was March 19th of 2024. He was seen wandering around a closed car dealership, and when he was confronted by police, he gave them a false ID. He then ran from a sheriff deputy, causing Deputy Cuso to give chase, during which he was injured in the process. Only when Deputy Phillips was able to apprehend him. He was also found to have brass knuckles on his person. In that case, we requested $25,000 cash or surety and were given $1,000 with 10% privilege. My concern is not only the three cases for which he has had multiple failures to appear, multiple bench warrants, he also has a hold out of Canton for $500, a 2002 conviction for home invasion second, a 2006 conviction for CSC fourth, and a 2003 conviction for OWI with an occupant under 16. At this point, I think that the bonds as set are an abuse of discretion, and I would ask for them to be raised.
Response?
I would definitely argue against them being raised. You know, my hope was, of course, to get them lowered, but
I know. We all have our hopes and dreams. And actually, the
Yes.
100,000 I set,
So
finding already an abuse of discretion with the setting of that bond. Motion for bond reduction is denied. Bond will continue in each case. I'll do you the favor of not raising the other bonds. Thank you.
thank you, Your Honor.
April 11th, 2024, 9 a.m.
State your name for the record.
C. Gill.
All right, thank you.
Your Honor, we would be doing an order for competency on this one.
You're requesting a competency evaluation.
Yes. And if we may ask to address bond when possible.
Forensic evaluation is hereby ordered. I'll set a competency hearing for, give me 60, but I don't know what's going to happen.
May 30th, at 9 a.m.
May 30th, 2024, 9 a.m. As to bond.
As to bond, Your Honor,
Do you
Mr.
have the orders prepared, or
Yes, I do.
you're just going to hold them? Go ahead.
As to bond, Mr. Gill is a 82-year-old who has health issues. There is a order for temporary guardianship and conservatorship that was entered yesterday. We'd be asked that he be able to be released to his guardian, Melanie Ellis, who's located inside Plymouth, Michigan, while this case is pending.
Your Honor, we have, our original request in this case was 25,000. The grant or the bond was set at 25,000 with 10% privilege. I understand that there was a request for guardianship or conservatorship yesterday. The guardian and conservator has refused to take the defendant into their home because of the abuse the defendant has perpetrated against his wife throughout all of the children's lifetime. We have also received additional statements from the children today that are in excess of 15 pages outlining the lifetime of abuse that has occurred over their 50+ year marriage. This is a strangulation case where the victim is 80 years old. He grabbed her by the neck, applied pressure, pushed her onto the couch, and was on top of her. The only way she was able to get him off was by physically pulling her knees to her chest and kicking him off of her. The only reason she reported this was because she told her pastor, and her pastor at her church said that she was not equipped to handle this type of situation, so she encouraged her to go to the police. I'm extremely concerned if the defendant is to get out, that there is a high lethality situation.
Well, hold on. He doesn't have a place to go, right?
I do not. Unless my daughter would take me.
She said no.
But that's the daughter, that's the guardian.
I believe so, yes, sir.
But my understanding is that's not going to happen.
Correct.
I don't have any place to go.
All right, Your Honor, at this time, we would withdraw our request, and then if any.
Okay, I'll have his bond continue and see if you can figure out something, but
Okay.
you know,
May I ask a question?
you can always ask. I don't know if I'll answer it. Go ahead.
I had the money in the bank, but I just couldn't access it because I didn't have, I don't know. I just didn't have the ability to access the $2,500. I had it, probably,
But hold on a second.
I'm sorry.
I don't know. Was it a conservatorship and a guardianship?
Yes,
So he doesn't really have access except through somebody else anyway.
Can I say
Yes.
something?
well, I would- that's not- then we can submit a motion at later date to modify
But
it
I might, oh,
until we figure it out. We don't, somewhere.
because I got the money, but I just couldn't access it because they wouldn't take it.
I'll come see it. Okay. Your Honor, we're all set.
Thank you. Continue. Yeah.
Good afternoon, Your Staff, Jonathan Emmons on behalf of the people.
Yeah, if you're up. Hey.
Did you want to fight this out?
Hey, Judge, let's start here. Come on. Come on.
Did you want to fight?
He can hear you, Your Honor.
All right. Mr. Heft, you are before the court on a felony complaint that alleges that on or about September 25th, 2023, the location of 2325 Twin Lakes Drive, apartment TA, Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of aggravated indecent exposure. Sir, do you understand the date of that charge? Do you understand what you're charged with, sir?
You understand your motherfucking queers, bitch. Quit fucking stalking me, you faggot ass motherfucker.
I will take that as a yes. That is a misdemeanor, a high court misdemeanor, punishable by up to 2 years and or a $2,000 fine plus court costs. Do you understand that?
Queer ass piece of stalking ass shit, motherfucker.
Sir, do you understand the maximum penalties?
Yeah, you can fucking open up the fucking door, bitch, like that. Stalking ass motherfucker.
Defendant is responding. It's inaudible, but I believe that he understands the maximum penalties. Count 2 is a misdemeanor offense that alleges that on that same date and at that same time that you did commit the offense of indecent exposure. Do you understand that charge, sir?
Hey,
I'm not hearing a response. He is present in the area.
he is present and listening, Your Honor.
All right. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. I will ask, although you're not responding, Mr. Heft, do you understand the nature of that charge and its maximum penalties? Do not hear a response. I will assume that the defendant has heard the charges and the maximum penalties. I will ask you first, sir, do you wish to be represented by counsel? Mr. Heft, do you wish to have an attorney represent you in this matter? I'm not hearing a response, but given the nature of the charges, the court, to protect the defendant's rights, this becomes a public defender case.
Bridget Cook, on behalf of the Public Defender's Office, for Mr. Heft.
You waive any further formal reading of the complaint.
Yes, we waive formal reading and we stand mute.
Defendant, every waive formal reading, standing mute to the charges. Court will enter a not guilty plea, demanding a preliminary examination. You waive timelines on this.
Yes, Your Honor.
All right. Timelines haven't been waived. I will set a probable cause conference.
April.
It ain't gonna matter. But
March 28th or April.
let's do April 4th. Could be a better month. Set probable cause conference for April 4th, 2024. That will be at 9 a.m. and this preliminary examination will be set from that date. As to bond in this case.
Your Honor, as it relates to bond, I think that Ms. Coons will be presenting the court probably with a motion for an order for finding of competency or a competency examination. I'll tell the court I was familiar with Mr. Heft in 15th. I'll note that he was found in that case. He had a misdemeanor malicious use of telecommunications service. That case, he was found opined originally to be incompetent to stand trial, but restorable. That's a 6-month misdemeanor. So not surprisingly, the Center for Forensic Psychiatry was unable to see him within that 2-month period of time. That time frame elapses, he is then found to be incompetent. He doesn't have a lot of resources to his name. I'll be upfront with the court. I spoke with his mother a handful of times. I recognize that he has an illness, and I've tried to figure out act in his best interest using his mom. As I understand it, he doesn't have any family that are willing to kind of stick up for him, except for other than his mother. I'm asking the court for a high cash bond, 10,000, 50,000, only in so much as a way, and I'm saying this deliberately. Not that I expect him to be able to post it, but I'm asking the court to consider it so high so that the mother doesn't feel obligated that she has to post it for him. I'm asking the court to put it in such amount so that she can't post it on his behalf. I don't believe that she's equipped. I've spoken to her. She's obviously a mother stuck between the love of her son and kind of everything that's going on. As I understand it, he has a 20-year history of schizophrenia. I don't think the court saw it while you were reading him the charges, but he came up and he punched the window during the reading of the complaint. I believe that given the nature of these charges, this is a case where he was making homophobic, racist slanders from the porch of his apartment complex, which he doesn't reside at anymore. I believe he's surrendered that apartment. And then he got people's attentions. They were able to use their cell phone video, record him as he was making these statements out loud in the courtyard, and then he exposed himself and gratified himself in an indecent manner. So I think he presents a risk of harm to himself, a risk of harm to others. He's got some vague connection through his Facebook account to Mesa, Arizona. He does have a previous history of failing to appear. I think that there's a lot of issues that go on. Underlying all of it is that he's mentally ill.
Jenner, I do have an order for competency. We would be asking for some type of nominal bond if he's possible to post it. He does have the support of his mother. He did have.
So you're asking for a forensic evaluation?
Yes.
I don't know how. I'm not going to sign that at this time. And the only reason I'm going to sign it, I'm not sure, unless your office has dealt with him. I understand the other orders that you'd be in a position to make that, or a request of the court to make that referral. So I'll set his bond at this time. I'll set it for the PCC. We can deal with it at that point. I'm going to set his bond. Yeah, I saw him. $50,000 cash surety, standard conditions, including no assault to behavior or use or possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. And I've signed that off. We're all set. See him April 4th. Thank you, Washington County Jail.
Thank you, Your Honor.
Court calls the case, People versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett, who is approaching, Your Honor.
I'm sorry, Your Honor, I'm dismissing my court-appointed attorney and representing myself.
Okay, so start with this. What's your name?
Chloe Whitsett.
Okay. And you're intending upon representing yourself in this matter?
At this time, yes, Your Honor, I am. I am dismissing the court-appointed attorney at this time, yes.
Okay, what's going on?
Until my family and I decide what law firm we are going to choose, I will be representing myself.
Okay, all right. So you need time to seek a attorney?
Well, not really, but I have a request at this time as I am representing myself.
Well, not until such time as I relieve Mr. Drukas.
Okay, thank you.
That's what I'm trying, I have not done so.
Okay.
So I'm trying to figure out what the issue is and what you're intending upon doing.
Dismissing the court-appointed attorney and representing myself.
Okay.
I'm sorry, at this time, I can't make it any clearer, and I don't
You're
understand.
not making it very clear to me at all. Because
Okay,
you're not listening,
I'm
just
confused.
talking. Are you going to hire an attorney
Yes,
or are you going to represent yourself?
today, Your Honor. I'm going to represent myself. If my request is denied by you, then I will be hiring an attorney. I can't make it any clearer than that.
So if I relieve Mr. Drucas, you're going to represent yourself.
Yes, sir.
So if they set it for a preliminary examination, you're ready to go?
This is I'm representing myself today. I don't know what all happens today, but I'm talking to the judge without the court-appointed attorney.
No, man.
Okay, well, I don't.
Don't listen. You don't you dare just lean on my podium and pretend like that. Not here. Okay, here's what I'm gonna do. I'm gonna pass the matter because if you come back up and start banging your nails on that podium, you're gonna be going with Mr. Allen. You may have a seat. Don't shake your head at me. Oh. Mr. Allen, might want to have a conversation with her and tell her that she better check herself before she comes back up here. Thank you, Mr. Durkin. Okay, so who wants to go next? Christian Philippe. Recalls the case, People versus Whitsett.
And Edward Drucas on behalf of Chloe Whitsett.
Your name.
Apologies on behalf of my client for earlier. I did have an opportunity to speak with her during that break and go over the process of where we are, what's going on right now. She did tell me that she would like to obtain a new attorney. So in the meantime, I can assist her with getting a copy of the discovery, getting a copy of the videos, which I don't have yet. I was going to be asking for an adjournment today to obtain those. So ultimately, I'd be asking for at least a 2-week adjournment. And I talked to her about her behavior in court, and I think that she has an understanding of that and will abide by anything the court orders her to do. So with that, I'd be asking for an adjournment of today's hearing.
Is all of that correct, Ms. Whitsett?
Your Honor, I would like to apologize. I had complete zero understanding. But yes, that is correct.
Ms. Whitsett, let me tell you something. I should have locked you up. You're lucky that I just took a deep breath and said, I don't know what's going on. I'm just asking her questions. And you come in here, I don't think we've ever seen each other. And you just come in here disrespecting me in this court. And I'm going to tell you something else. That man standing beside you right now, it's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone. So while you may not want him representing you, he just saved you. Remember one other thing. Funny thing about judges, we have exceedingly long memories. You come in here acting like that on the next day, I'm not even going to ask any questions. You are just going to go. Are we clear?
Yes, Your Honor.
April 11th, 2024, 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Thank you.